Hi, everyone. Welcome to our Beyond Immigration Law podcast, where we explore the full spectrum of the immigrant journey from cultural integration education to policy and career development. I'm your host, Charina Garcia, and I'm the strategy and innovation partner at WR Immigration. As a longtime immigration attorney and daughter of immigrants, I'm passionate about the stories that lie beyond case numbers and visa categories. Today's episode is Tax and Immigration Connection, what global employers need to know. We're going to be talking about how does tax intersect with immigration. I get a lot of questions about tax, and the minute I get a question about tax, I always refer it out to Krystle, who's a tax expert. So, Krystle, why don't you introduce yourself?
Hi, I'm Krystle Owynn. I'm a partner at Spott, Lucey Wall, a CPA firm. We specialize in U.S. cross-border issues for businesses and individuals, and happy to be here with you, Sharina.
Thank you. And as I always do in my podcast, I always want to know, how did you get to where you are today? So, Krystle, why don't you share your career journey?
I started my career journey on the path to becoming a CPA. I got a 4-year degree in accounting in Washington State, where I'm originally from. Uh, and when I graduated, I found a job here at Spott, Lucey and Wall. So I've actually been here my entire career, over 15 years with this firm, and it's been a journey. I became a partner in 2020. Along the way, I studied for and passed the CPA exam, and completed a master's degree in taxation with the firm's support. So it was important to me to find a firm that would support my career goals. And it's been really interesting working with international folks the whole time.
So, if you had any tips to give to anyone in college right now and thinking about a career path, what are some of the tips you would give them about your
I
journey?
I would say consider accounting as a major, even if you don't want to do international tax. A big concern I hear for a lot of students these days is one, it's really hard to find a job in general as a new grad. There is abundant opportunity in accounting and job stability. And so there's something for a lot of people. Whether you're more of a numbers person or a social person, you need some combination of both, but there's a lot of different options available.
So, do we have to worry about AI in your field?
I think AI is really going to be helpful in the field of financial statement auditing because
Yeah.
there's a lot of automated sampling that's really going to save a lot of time and effort. Unfortunately, that's also going to cut some jobs, but I think that's just going to make them more efficient and better able to do their jobs. Accounting, and especially as a CPA serving the public, it is a service profession
Yeah.
and people need someone to talk to. That's
Yeah.
not going anywhere. AI is going to be a great tool for us, but we very much still need accounting grads. Very excited about some changes that are starting to roll out on the national stage to make it easier for people to become a CPA. Currently, a lot of people have to get 5 years of school, so they go and get a master's degree in accounting, which is time consuming, expensive, and they're working on some alternate pathways where you really only need a 40-year degree and 2 years of experience to get licensed, which I think is just as valuable, if not more.
Well, I can hear the passion in what you do, so I'm excited to talk to you about, international tax and immigration. So, Krystle, I gotta tell you a story. So, my daughter got a summer internship, and then she called me and she's like, "Mom, I got paid, and they told me I would get $1,000. But mommy, they took out $200 for taxes." And she says, "I thought I wasn't gonna be taxed." And so how does that differ if you're a US citizen and if you're an F1 student who's not subject to FICA taxes?
There's a difference between immigration and tax residency. And there is a very big difference between uh, how US residents are taxed versus how non residents are taxed. US residents are taxed on their worldwide income, no matter the source. US non residents are only taxable in the US on their US source income. Source of income is determined in various ways, but just to focus on salary and wage income, that's sourced based on where you're physically performing. And so if you're physically working in the US, that would be considered US source income and taxable in the US in general, even as a non resident.
So for the students, you basically don't get taxed on certain employer like FICA. But then when they hit the 5 years they've been a student, then they actually will be taxed for their FICA. Because that's usually where employers are coming to me and they're saying, Sharina, we have to figure out how long this student has actually been here as an F1 student. And then they figure out the whole tax. And then sometimes they actually have to go back and get the tax, which the student's not really happy about, right? So that's what I've commonly seen. And then the most common transition is going from F1 to H1B. So, Krystle, when you become an H1B worker, are you subject to FICA and all the other taxes and Social Security and all those other things?
Yeah, so that's a new one, but as an H-1B holder, they're generally going to be a US tax resident. Uh, there are 3 ways to be a US tax resident. One is a citizen, 2 is a green card holder, and 3 is a resident under the substantial presence test. And that's actually a 3-year look back test. It's not just the current year you look at. You look at 100% of the current year days, 1/3 of the prior year days, and 1/6 of the year before that, and add them all up. If you are here at least 183 days, then you're a resident for the tax year. And in that situation, you're taxable just like any other US person.
Okay, so everything, Social Security, FICA, all that stuff gets taxed from you. Okay. And then, how about our L1 intercompany transferees? I know that when I'm guiding clients, their expats are always worried about tax, right? How will they be taxed? For tax equalization or expats who are coming to the US and have all these tax questions, how do you usually advise them? Because, they always say to me, I don't want to be taxed twice.
Most people's number one concern, I don't want to be taxed twice. And for the most part, the equalization that the company puts in place for them is going to take care of it. How does that actually look on their US tax return? Um, if they happen to be taxed in their home country and also in the US, there's something called the foreign tax credit. That's a way to minimize that duplication. And so they're not paying tax twice on the same income. They might be taxable in the US and, for example, have a reduction for any home country taxes.
Okay. Okay. So that's good. Basically, when someone is considering transferring over as an expat, they start the conversations with the company. Company has a equalization agreement, and then usually they will refer them out to a tax advisor as well to help them with their taxes. Um, so now let's talk about our visitors, our B1 visitors. I'm getting a lot of questions about the B1 visitors. I know one of the toughest things is monitoring these business travelers who come in, right? Because they just come on the plane and they come. And then I hear some of the challenges is how do we monitor them from an immigration perspective and then also from a tax perspective. So Krystle, for our business travelers, how do they normally keep track? Cuz and what is I know you mentioned the substantial presence test. How does it work for our business travelers?
For our business travelers, it's really important for them to keep track of their calendar and really be aware of how their days are adding up year over year. And again, think about what are they doing when they're in the US? Are they working while they're physically here? Usually, I don't hear about them at that point. Usually, they'll come to me when they've got more of a stable situation or an employment offer. But in the period that they're kind of in and out, and maybe they're on foreign country payroll, and they happen to come over to the US and work for a short period of time while they're here. Uh, that technically is US source income, like we were saying, physically performed in the US is US source income. There are some de minimis exceptions and exclusions if it's, a really short trip, uh, very minimal. If it's going to be somewhat more extensive, there's uh, more help available in tax treaties. And so, if we have a tax treaty with your home country, say the UK, for example, uh, if you're on home country payroll in the UK and happen to be working in the US, I won't speak to the immigration side because you really shouldn't be working on that
Yeah, you
B
should be
visa. But if
no.
you happen to be working, speaking from the tax side, there is a treaty benefit if you're not here more than 183 days in that calendar year, and you're on home country payroll, and that company doesn't have a substantial business activity in the U.S. So there's minimal de minimis help in the Internal Revenue Code. There's more help in the treaties if you happen to be here for a longer time. But again, that's on the tax side. Immigration is another matter.
Yeah, and that's I think where the confusing part of it is because when we advise our business travelers, we always tell them you're not supposed to be working here. You're only supposed to be here for meetings. And then they're here for a full 90 days. And I said, okay, what have you been doing for 90 days? Right. So theoretically, we want them not to have to be able to file taxes because you're not supposed to be working in the United States. Um, but if they have been here for more than the 100 what do you say, 183 days? Is that 180? 183 days. Are they gonna be subject to tax regardless of whether they're here as a visitor? Because visitors could actually extend their stay up to 1 year.
Well, the thing is, if they breach that under 183 days, they're actually bringing their whole annual payroll into the US, which
Wow.
they don't want to be doing that and triggering US tax residency for themselves. If they are working here and not breaching that 183 days, technically they still do have US source income as a non
Okay.
resident. Again, a gray area, and I tend not to hear about those situations until people are more serious, but when people are in that in between zone, technically many of them may have US source income.
Okay. And then I always get this question because, we get people stuck overseas when they're renewing their visas, and they always ask me, can we keep them on US payroll? And they could be stuck overseas for 30, 60, 90 days. Does that impact tax in any way if you're not physically here, but your payroll still keeps coming in to a US bank?
It really is based on your physical performance of the services rather than who's paying you, but where are you doing the work as the employee?
Okay. So probably I will just refer them to you, Crystal, when I have questions on those things. Um, but Crystal, let's talk about green card holders. And I know there are some special rules about green card holders. What have you seen in your practice as it relates to green card holders and worldwide tax?
So, green card holders, I often get the question as well. I'm on an H-1B, I'm transitioning to a green card. What does that mean for me? What do I need to be prepared for? And actually, from the taxation perspective, on an ongoing basis, there is no change. Remember, because there's three ways to be a resident: citizen, green card holder, or substantial presence. And if you already met the substantial presence as an H-1B, changing to a green card isn't going to change any of your daily or annual reporting. What is important to be aware of is your long-term plans. If this green card is valuable for the time being, but maybe not your entire life, I see some people with plans to eventually return to their home country. And what they need to be aware of is the expatriation tax that can kick in if they've been here any 8 of the last 15 calendar years. There's a potential deemed recognition of any unrealized gain on their worldwide assets at that point. And so if they've got appreciated assets, there could be a big tax bill come the time they relinquish that green card.
So basically, Crystal, if I'm a green card holder, even from day one, Am I subject to tax for all my income worldwide, even if I have assets overseas?
Yes. So, as a green card holder, even from day one, you are subject to worldwide taxation. And another thing that people are also unaware of or learning about as they become green card holders is reporting of their foreign assets. The US wants a lot of information from people, especially people who have foreign assets, bank accounts, your foreign pension account. They want to know about all of that, your family business, everything. And so there's a lot of information that needs to be reported that they might not have been prepared for.
But if you're an H-1B or L-1 or F-1 student, you don't need to report that on your
You
tax.
actually also do. So those filings apply to anyone who is a US resident.
Oh,
So the F1 we can exclude if they're a non-resident, but the H1B, the L1, the green card, if they've got the most common filing is the foreign bank account report. And so if they've got their bank account back home and there's at least $10,000 in the combined value of all of their bank accounts back home, including their pension, then they've got to report them on an annual basis. It's not a taxation, but it is an informational disclosure. And it's a very important one because it carries a $10,000 penalty for failure to timely file. There's more that the US wants from people than simple taxation when you become a US resident.
okay, Crystal. Well, I get all these emails about this one big beautiful bill act, and I'm not really sure what that is. So, does that impact our immigrants or our non-immigrant workforce?
Yeah, so the act is definitely in the news. People are wondering about it. Thankfully, for the everyday person and for foreign national workers, it really doesn't change much on a day to day. What it's done for the most part is extend tax treatment that's already been put in place with the TCGA of 2017. It's really extending or making permanent many of the tax rates, tax treatment that was put in place at that time. One thing, especially for our California workers, that is helpful is there's been an increase in the SALT cap deduction. So that's something that was capped at $10,000 and really wasn't very helpful for our California and New York workers. And so now that's been raised to 40,000, which should be quite helpful.
What is salt cap? What's salt cap?
So Uh, this isn't something that's going to affect everyone. The salt cap is something that relates to whether you itemize your deductions or take the standard deduction. In recent years, the standard deduction has actually been plenty for a lot of people, and many people no longer need to itemize their deductions. Uh, However, if you've got additional deductions, for example, you bought a house, you've got real estate taxes, a mortgage, you might be landing in the area of itemizing your deductions. And what happened with TCGA is they put a limit on how much you can deduct within your itemized deduction basket of taxes. So that included your real estate taxes, your California state income taxes. And with California income taxes so high, many people were already getting limited on their deductions. So if you happen to be an itemizer, that's something that's helpful. If you're under the standard deduction, that's still plenty for most people, and you don't have to go and track down your receipts.
Okay, and then I have another follow-up question for you because we have our pool of population of people that are under deferred action or DACA or temporary protected status, and they're working. So basically, what you're saying is even those individuals, as long as they're working in the United States, they should be paying their taxes like other normal US citizens,
If
correct?
they're, meeting that substantial presence test, then yes, they would be a US tax resident for tax purposes.
And this even includes people without work authorization who are here without legal status, I guess is the word, legal status.
Yes, and that's where it gets tricky, where immigration and tax don't necessarily see eye to eye. So, whether you're here legally or illegally and physically working, that is technically US taxable income.
Yeah, and I get a lot of these questions about whether if I'm undocumented, if I should be paying taxes, right? And based on your interpretation, doesn't matter what your immigration status is, whether you're documented or undocumented, an expat in H1 and F1, under the IRS rules, you are required to pay taxes if you are physically working in the US and living in the US, correct?
Technically, yes. How much does that happen in real life? I would expect not as much as it needs to from a technical perspective to be fully correct. Filing a tax return also requires having a US tax ID number. And so if you don't have work authorization, you would need to apply for an individual tax ID number. And that is another process. So if you're undocumented, I'm not sure what that process looks like, but it is something that's needed for filing a tax return.
So, Crystal, can you just tell us what is the process to get an ITIN?
So the process to get an ITIN generally involves you can do it through the IRS, and it's maybe a long and strange process where you're giving up your U.S. passport while they look at it, or you can work with someone who is a certifying acceptance agent who can physically verify your passport and identity and help you apply for the ITIN. The ITIN application goes with your tax return. And so if you've got a spouse here with you who does not have a social security number, it might be valuable to apply for an ITIN with your tax return process so that you can file jointly. Non residents are generally not eligible to file jointly. So you need them to be considered a U.S. resident. There's some elections that happen on the tax side, and sometimes it makes sense, sometimes it doesn't. But having your spouse get an ITIN can be a valuable tax savings.
Yeah, because we have H-1B workers, L-1, L-2s, H-4s, dependents who some work, some don't work. I mean, if you work, then you're gonna go get a Social Security number because you're work authorized. But we have some dependents who aren't able to work or just don't wanna work. But my understanding is that they're still reflected on the tax return as a dependent. And that's usually when I see that they have an ITIN. We had to actually get all that information when they changed the rules briefly in Trump 1.0, and our clients actually had to provide all their tax returns and all their asset information. So that's the only reason why I became familiar with the whole ITIN situation.
There's actually been another unfortunate change for families moving over. So, one of the benefits available to families is the child tax credit, which is something that reduces your U.S. tax bill. Now it's 2,200 per child. This is something that starting in 2025 is only going to be eligible for kids with a social security number. And
Oh,
so they're
wow.
taking away for the I-10 kids. It looks like there still is some ability to claim a smaller credit for another purpose, if your children do have an I-10, but they really are taking away the biggest benefit unless they have a social.
Yeah, and those would be our H4s, dependents, right? And then also our L2 dependents. So I think that's one thing to take note of. So, Crystal, can you just give us like some common things you have seen in the work that you do as you advise on international tax, like just some common fact patterns that you've seen?
I tend not to work with the large workforce coming over. There's a large workforce coming over. They get their first year of taxes on the company, and then they're on their own to come look for an advisor. Usually, after that first year, when they're uh, off of the company packages, when I get the call, uh, and sometimes what happens when I start to work with them and interview their situation They've got more going on than was in that, return they originally submitted because they were focusing on their employment income, they weren't focusing on if they're a resident, maybe some income they had back home, maybe some investments they had back home, and so it's a discovery process for them, even though they may have been in the US tax reporting system, sometimes things are still new and they continue to learn.
Yeah, and what I've seen most common is I have my C-suite, right? And they have been living in the US and they're on an L1 visa and then they want to get a green card. And usually they're talking to me, and I always whenever people ask me about green card, I always say, talk to your tax advisor as well. Because the last thing I want to do is for the company to spend all this time and money. And at the end of the day, they're going to get a huge tax bill. So, Crystal, one thing that I have seen also is when the C suite or executives want to give up their green card because now they're being transferred back to a different country. And so I've seen them, want to abandon their green card, and I think you had mentioned that there was actually a certain time period, right, that they still could be taxed
There
even if they gave
is.
up their green card.
There is, and it's maybe a shorter time period than they have in mind. So it's any 8 out of the last 15 calendar years, and any day in a calendar year counts. So if they originally received their green card on December 31st, that's a year gone.
Wow.
So they really need to be thinking about their longer term plans. I say by year 5, they don't need to have a decision made, but they need to start thinking about where they're going to go and if they are going to pass that 8 years or not. If if it's a situation where they do plan to return home, their situation can be a whole lot simpler if they don't hit that 8th year. So giving the green card up in year 7, uh, and you just have to be careful about how you're counting the years, then they don't hit a status called long-term permanent resident. And it's that long-term permanent resident that can be subject to the exit tax.
Okay, got it.
Another thing I see on the green card side is sometimes people go back home and their physical card, the date on the card expires. And they think that means they've relinquished their green card, but actually that's not the case. And so they really still are a US tax resident green card holder, even though the date on the card is expired. And so that's something that surprises some people
Yeah.
when they say, "Oh, yeah, I haven't been in the US for a long time. My card expired." You're still a resident.
Yeah, that's when I refer them to Crystal. When I say you need to call Crystal, because we do have permanent residents living outside who frequent and come in once in a while. But I always make sure when they're coming in because they will be questioned when they come in if they've been filing their taxes, if they've been requesting that foreign earned income credit or something like that. And then if they want to apply for citizenship, all those questions actually do come up, and it could impact their ability to keep their green card, or their ability to get citizenship. So it's really important that um, people talk to a tax advisors are going to spend lots of time outside of the US. So, any other takeaways you want to give, Crystal, before we close out?
Yeah, the other risk, and this is a bit more on the immigration side, is there's a risk of getting your green card pulled if you've been gone too long.
Yeah.
And that's something you don't want to have happen on the tax side because you have no planning opportunities. It just happens when it happens. So staying ahead of the curve and proactively planning is helpful for a lot of people.
Yeah. And if people want to find you or have questions, how can they reach out to you?
They can feel free to reach out to me on LinkedIn and connect.
Great. So I want to thank Crystal for sharing your insights today. I learned a lot about tax and global mobility. So whether you're an immigrant, a business leader, or global mobility manager, it's very important to understand tax and immigration law because it's all interconnected. Be sure to subscribe to Beyond Immigration Law for more insights and follow us on LinkedIn for updates. Until next time, thank you, Crystal.
Thanks, Sharina.